First of all, good afternoon, ladies and gentlemen. And I would like to say another time, again, how delightful I am to participate in this project and how I think it's important to have these projects on comparative aspects, comparative law aspects. As at the Faculty of Law in Novi Sad, on master studies, I lectured subject comparative family law, and on doctoral studies, I lecture two subjects. One is comparative marriage law, and the other is comparative parent-child law. So it is very important for me to have these books and also articles on comparative law. So it's important for my students to read it and to learn for the exams in these subjects. And just one fact that I learned a few days ago, which I think it's important to mention to all of you, because we are now linked with the Ferenc Mádl Institute, and I heard that Professor Mádl was the visiting professor at the University of Novi Sad some time ago, when we have complete law studies not only in Serbian but also in Hungarian. That was, I don't know, 30 years ago or something like 40 years ago. Okay, now I will start. In contemporary family law, decision-making process on important issue concerning a child becomes significant in theory and practice. This is due to modern concept of who is considered a subject to family relations. Not only parents, but the child himself or herself becomes important party to family relations. The equality principle considers equal role of mother and father in family relations. As it might be three persons who are able to participate in decision-making, there are situations of their disagreement and the conflict is possible to arise. On the other hand, in historical context, things were different. In Serbia, before World War II, Civil Code of the Kingdom of Serbia regulated family issues. The basic institution concerning parent-child relations was paternal power. The father had some prerogatives exclusively. These are the right to represent the child, to give marriage permission, to manage child's assets as a legal representative of the child. The rule for resolving a disagreement concerning child's issue between parents states the father's word prevail. After World War II, in former Yugoslavia, parents became equal in parent-child relations. However, that was also after the World War II, immediately in 1946. However, in some European countries, the father's role was predominant until 1980s. For example, in Italy until 1975, and in Greece until 1983. Making decisions on important issue concerning a child would be analyzed in two different family situations, intact family and separated family. The decision-making process depends on the issue involved, if the issue is considered important for the child, or it is on daily importance. Okay. The issues considered to be significant influence to the child's lives in terms of Serbian Family Act 205 are specifically the education of the child, significant medical interventions on the child, the change of the child's residence, and the disposal of the child's property of great value. In comparative European family law, Commission on Family Law in Principles of European Family Law regarding parental responsibilities, did not define important matters. However, in Principle 3, this principle contains a list which serves as an illustration. It refers to issues such as the determination of the child's residence, education, medical treatment, and the administration of property. The principles do not provide a criterion in order to evaluate whether or not an issue is important, but decision with a long-lasting effect for the child should, however, be considered as important. I think this definition is acceptable for all countries. Long-lasting effect is very important. It could be seen that the issues which are considered important, comparing Serbian law and the principles, are similar. Serbian law contains a non-exhaustive list of the issues which are considered important, as well as principles. Thus, a long-lasting effect for the child as a criterion is the issue is considered important, recommended in principle, seems appropriate, of course, for the Serbian and the court practice. Okay, sorry. In Serbian family law, parents exercise parental rights jointly and consensually when they cohabitate. Married parents automatically acquire parental rights in the moment of the birth of the child. If parents are not married, mother automatically acquires parental rights in the moment of the birth of the child, and father when paternity is established, by father's acknowledgement or by court judgment. Thus, if parents cohabitate and if paternity is established, in the situation when parents are not married, parents exercise parental rights jointly and consensually as well. In the intact family, problems concerning decision-making might arise in the situation of potential conflict between parents, their child, or third party. The parents might have different stance from widely accepted stance in society, for instance, concerning medical issues. One example of this kind of conflict concerns blood transfusion, as some religious groups oppose to it, which creates an obstacle to perform medical intervention on the child. Another example is approach to serious medical problems of the newborn child, as sometimes parents refuse life treatment. In the United States, for example, refusing the life treatment is defined as medical neglect and forms child abuse according to the American Act on Child Abuse 1984. This act orders performing medical treatments to the child with defects. In rare situations, parents themselves might have different approaches to some issue, but if the family is intact, they could be able to solve the disagreement inside the family, presumably. The same presumptions might be true in the situation if the conflict arises between parents and their child if the family is intact. But if the family is separated, when parents are separated, according to Serbian terminology, do not live together, there are two forms of exercise of parental rights, joint and independent. In the Serbian legal system, joint exercise of the parental right in the situation if parents do not cohabitate had been introduced in Serbian family law by the Family Act 205. The parents might not live together as a consequence of the divorce, quitting their mutual life, but not formally divorced, quitting their heterosexual non-marital cohabitation, annulling their marriage, or if parents never live together. A provision states that parents may continue to exercise the parental rights jointly even after they do not lead a common life, provided that they make an agreement on joint exercise, and provided that the court is satisfied with this agreement, and if the agreement is in the best interest of the child. This kind of parental agreement enables parents to exercise all the rights and duties comprised within parental rights. If they do not lead a common life and is intended to avoid the hostility and antagonism caused by court decision granting the exercise of the parental rights to one of them. The wording of the provision on joint exercise confers great freedom upon the parents, since it enables them to agree on the matters related to their child in a manner which is most appropriate for their own particular situation. The only limitation is the parent's duty to reach an agreement on the issue of the child's domicile. The domicile followed by the child's address must be established for the sake of legal certainty, and especially for the sake of facilitating legal acts, communication of legal documents, notification, etc. In the opinion of the Commission which produced the draft, this limitation does not necessarily mean that the parents cannot agree on so-called alternative residence of the child. In comparative family law, there are different approaches regarding the necessity of parental agreement on joint custody. For example, in Sweden, courts have the opinion to avoid joint custody even when the parents have not agreed. However, if this is the case, joint custody should be used with great caution and sensitivity. In France, the judge has the power to order, even if the parents are not in agreement, that the child's residence should alternate between the homes of each of the parents. In some jurisdictions, joint parenting after divorce or separation becomes a rule rather than exception. Okay. A specific solution of Serbian law is that the right of the other parent to decide on issues that significantly influence the child's life jointly and consensually with the parent exercising the parental right. In a way, this is theoretically inconsistent, as the rights of parents are similar concerning decision-making in both situations, joint and independent exercise. Why is that? Why we have the same situation of parental agreement, even if it is joint custody or sole custody? This is because there is an assumption that independent exercise of parental rights would be predominant in practice, because we need, parents need consent to have joint custody. And there were a fear that the rights of the other parent would be actually decreased in practice if act abandons right of the other parent to decision making, if the exercise is independent. So before having joint custody, if the independent right of the custody was introduced, the other parent had the right to jointly make the decisions. That was situation before joint custody, and after it could be somehow decreased if we adopted the solution that when the independent custody is in question, the other parent does not have the right to decision making. One of the biggest problems in nowadays is relocation of the child, and it could be a consequence of the international child abduction. The removal or retention shall be deemed as wrongful under Serbian family law in all situations where there is an absence of agreement with the parents on change of habitual residence, and that is really a problem in practice. Okay. And also there is another issue, another point, and this is the right of a child to decision making. According to Serbian family law, a child who has reached 15 years of age and who is capable of reasoning has the right to decision making on important issue regarding himself. These are to give consent to medical procedures, to decide which secondary school she or he will attend, to decide with which parent he or she will live, to decide on maintaining personal contact with the parent, the right to change a personal name, to undertake legal affairs through which he, she manages and disposes of income or property that has earned through employment. This is for the child of 15 years of age. A child who is 16 years of age and able to reason has these rights: to acknowledge fatherhood, to give consent to a knowledge of fatherhood, being the underage mother or a child, and to request to conclude a marriage. A pregnant woman who is 16 years of age has the right to independently request for an abortion. But also at the age of 10, there are some rights of the child, and the child who is able to reason can give consent to adoption, to fostering, has the right to propose the person who shall be appointed as a guardian, has the right to give consent to change his or personal name. And the Act on Patients' Rights, enacted in Serbia in May 2013, stated explicitly that if the child refused the treatment, the doctor has to ask for the consent from the legal representative of the child. So it could be said the child has a right to consent to a medical procedure, but if refuse medical procedure, then the medical doctor has to ask the consent from the representative of the child, from the parents in most cases. So the second part of my presentation is resolving the conflict. What would be the best way to resolve conflict if we have the conflict between parents? In the situation of joint exercise of parental rights, there are different solutions in dispute resolution in comparative European family law. Each country has several options for dispute resolution. The competent authority for dispute resolution could be the court or the social institution. The courts have competence in most cases, in 18 out of 22 countries, for example, Austria, Belgium, Bulgaria, Czech Republic, England and Wales, France, Germany, Greece, Ireland, Italy, Lithuania, the Netherlands, Norway, Poland, Portugal, Russia, Spain, Sweden. In some jurisdictions, the competent authority has an option to try to conciliate the parents. This solution exists, for example, in France and Sweden. In some jurisdictions, competent authority can authorize one of the parents to act alone with regard to one or more specific decisions. This solution exists in Belgium, Finland, Germany, Italy, Spain. In some jurisdictions, the competent authority can charge one of the parents with exclusive exercise of parental authority. This solution exists, for instance, in Belgium, Germany, Sweden, Denmark. In England and Wales, the competent authority can determine with whom the child lives. The main difference in comparative laws concerns the existence or not of an option for the competent authority to resolve the conflict by itself. The competent authority has the possibility to resolve the problem in the interest of the child and leave joint exercise of parental responsibility to both parents in some countries like Austria, Belgium, Bulgaria, Czech Republic, Denmark, England and Wales, France, and also so. In Russia, for instance, the competent authority can give instructions as to how the dispute should be resolved. The competent authority cannot itself resolve the conflict in Sweden, Finland, Germany, Italy, Spain. So we have different solutions. In the legal theory and the Serbian Family Act, Act, there is no explicit provision which would authorize the court or any other authority to make a decision on important issue concerning the child by itself in the situation of the conflict. In the legal theory and court practice, there are different opinions on how to resolve the problem of lacking the necessary consent. Okay. One way for resolving the conflict is in the special procedure for protection of child rights, a procedure in which a court would have to assess whether one parent's decision without the necessary consent of the other parent would be in the child's best interest. This opinion derived from Family Act, which regulates the special procedure for protection for the child's rights. The Supreme Court of Serbia has expressed the opinion that there is no possibility for the court to make a decision which would substitute necessary consent of the parent as well. In one particular case, consent was necessary for moving abroad with the child. Instead, Supreme Court has stated that court should decide to partially deprive parent of parental rights. The legal consequence of such decision is that the consent of that parent would not be necessary for taking the child abroad afterwards. According to Family Act, a parent may be partially deprived of parental rights if exercise parental rights negligently. He/she may be deprived of the right to decide on issues that significantly influence the child's life. Of course, there is a question if this possibility is adequate or not. And there is no doubt that court is authorized to partially deprive of parent of the parental rights if he refuses the consent, but only if this is negligent on this side of the person. So refusing a consent per se cannot be qualified as negligent act. And in this particular case, the father opposes to removing the child abroad, but not as a negligent act. But on the contrary, he wants to have contacts with his child, to have opportunity to take all necessary decisions, to have all contacts and so on. So, in my opinion, that was not a good solution. Even the Supreme Court and court practice, in most cases, adopt Supreme Court opinion. In this case, in my opinion, that is not very good solution because there is no negligence, and it's right of a parent to have contacts with the child. So, okay. So I will just mention some solutions for the de lege ferenda in Serbian law, which I think it would be good and for resolving the conflict. Having in mind specific concept on decision-making on issues that significantly influence of child's life, which might have as a consequence great number of parental conflict in practice in future, the need of explicit regulation of possible ways for resolving the conflict is evident. On the other hand, the solution to deprive the parent of parental rights is rather drastic and suitable only if the parent acts negligently. The solutions which would be suggested for resolving the parental conflict would be as follows. The competent authority should be the court, as the decision in question is one of the most important issues concerning the child. The court should have the competence for making such decision, as judges who are in family law has to be particularly specialized in the field of family law and children's rights. The court should have different options in resolving the conflict. First, to try to conciliate the parents through family mediation conducted by competent authorities, for instance, guardianship authority, marriage or family counseling service, or other institutions specialized in mediating family relations. In addition, the court should have an option to authorize one of the parents to act alone with regard to one or more specific decisions. And at the end, the court should be authorized to make decisions by itself. The court should have discretion to choose option or options which find most appropriate for the current situation in the child's best interest. This will depend on different circumstances. For instance, is the matter urgent? Is the parental conflict exception or frequent, etc. Thank you for your attention.